You have just found out about another infringer, a competitor who is using a trademark or copyright that is blatantly similar to yours. It looks the same, it sounds the same. It will easily confuse another customer into believing that that particular mark is your trademark or that of your company. Naturally, you are very irritated and you want to dig this person's grave. However, you still want to give them another chance before you go to the court, or you want to see if the dispute can be resolved without approaching the court and filing a suit. What is there that you can do in such a scenario? You can ask your attorney to send this infringer a cease and desist notice. What is a cease and desist notice? It is a legal notice sent by the owner and prior user of a registered trademark or copyright through their attorney to a party that is infringing upon or copying their registered trademark or copyright. And in this legal notice, you can ask this infringer to cease and desist or to immediately stop the usage of the infringing mark, that is, the infringing logo, the infringing name, or other intellectual property that is infringing upon your registered intellectual property. Now, the question is, how will you achieve this objective? How will you convince this person to stop from infringing your intellectual property just through a legal notice? Well, this is the place where the role of a lawyer comes in. As a lawyer who has dealt extensively and continues to deal extensively in trademark and copyright disputes, I have issued several cease and desist notices on behalf of my clients to infringers. And in most cases, I have myself advised the clients to first issue the cease and desist notice before going to court in order to stop the infringer. I only advise them not to issue such a cease and desist notice and to approach the court directly if there is a specific reason that they have for taking the infringer by surprise. For example, if they want to have a raid conducted against an infringer and seize the infringing goods, or any counterfeit goods need to be seized on the spot, then I would advise them to approach the court directly and not send any cease and desist notice. This is because if in such cases also they send a cease and desist notice, the infringer would be alarmed and would cover up their tracks in a very clever manner. Now, for cases where we are issuing a legal cease and desist notice, it is important that we draft it very well to enhance its effectiveness. And it is important that in this notice, as lawyers, we make sure that we put all the details about the history and usage of our client's trademark, the details of the trademark registrations of our client in India and across the globe, and any past orders or judgments by courts in favor of our client, or any orders in which the courts have granted injunctions to our client and restrained other third parties from using marks that are identical or deceptively similar to those of our client's registered trademarks. Right? So in this notice, we will ask the infringer to stop using the mark that is similar to our client's mark and to undertake not to use any other mark, name or logo or domain name that is similar to that of our client. We will need to explain to them, this third party, that our client's trademark has been adopted before and is prior to this infringer's mark, and thus our client is legally entitled to stop them from using any similar name, any similar mark or logo for the same kinds of goods or services or in any related industries also, as their usage of this kind of the infringing mark could easily deceive consumers into believing that their mark or their company is somehow associated with our client's company. Right? So many a times the infringer will issue a cease and desist reply, denying a reply to a cease and desist notice is what I mean, and they'll deny your averments and refuse to comply with your demands. Right? Their lawyer may even make some legal arguments. For example, they may argue that they have also been honestly using these marks for a very long time, or that customers recognize this mark to be associated with their company, you know, or other reasons they may give, right? But in such a scenario, what you would have to do as their lawyer, or what your lawyer, if you're a business owner listening, what your lawyer would have to do would be to issue a rejoinder notice in response to the reply. And in this rejoinder notice, your attorney will have to respond to all their legal points with even stronger arguments and give them a final warning of complying with this rejoinder notice and to do as you ask within 7 days. Failing which, you will definitely approach the court. So you have to clearly tell them this, that if within 7 days you don't heed this final warning, we will approach the court and we will get an injunction against you, right? Many a times, this final warning may bring the infringer to the table for negotiations. They may request, though, for some time to transition to the new mark, because they'll have to make necessary changes to their packaging, brand name, website, and other material that they have with the infringing mark or infringing name. So you may then drop an undertaking specifying the time within which this infringer will stop using the infringing mark. And the undertaking must also specify that the infringer will not use the infringing mark or any mark identical or deceptively similar to your mark in the future either. This line is very important. Many a times, what will happen is that the infringer stops using the infringing mark temporarily, only to switch over to another mark that is also deceptively similar to your mark, with a different spelling, slightly different pronunciation, or the addition of a suffix or prefix. Once this undertaking is signed and the infringer stops using the infringing mark, the process is now complete and your objective has been achieved. You can then also claim damages from the infringer. Now you just have to keep track and make sure that the infringer does not breach the agreement and again start using the infringing mark or any other mark that is identical or deceptively similar to your mark for the same kinds of goods or services. If you later find out that the infringer is violating the terms of the undertaking and still infringing the trademark or copyright that belongs to your client, or that belongs to you if you're the business owner listening in this case, then you should immediately approach the court and you will get an injunction and damages promptly from the court in such a case, as the court will also see that the infringer has himself admitted that he was infringing upon your trademark and he is now dishonestly and deliberately infringing upon your trademark again. So if in a certain case you send the cease and desist notice to the infringer and they refuse to comply with your demands in their reply, right? If they refuse to comply with the demands in their reply to your cease and desist notice and then do not even come forward for any kind of a settlement, you still have a very strong case now to get an injunction from the court, as now you can tell the court that you sent a cease and desist notice, tried to resolve the matter amicably outside the court, but it was to no result, and that's why you had no option but to approach the court for an injunction. So the court in such a case will give you an injunction even faster on the first date itself, and will be less likely to have that injunction overturned in the future. So I hope that today's episode provided insights into solutions that IP attorneys can provide for your problems. And as an IP attorney myself, I can personally vouch that timely action against infringers by taking the right legal steps can help protect your brand and grow its value in the long run. So, stay tuned for more exciting episodes and keep learning about the fascinating world of IP law. Thank you. Namaste.